We're going to start now. This is our second lecture. But still, we are going to discuss section 1. Expect that you already watched the partial discussion on section 1, and I hope you had already read the reading materials I had given. But still, we go back to section 1. Section 1 is very important in the negotiable law of instrument because it discusses everything from A to E. We're talking about first, why is negotiable instrument then invented by the merchant in the medieval times? It says negotiable instrument was invented by the merchant in order to move supplies or lots of trading and substitute for money. It is said it is a written contract for payment of money which is intended as a substitute for money, and it passes or transfer from one person to another as money in such a manner as to give holders the right to hold the instrument free from defenses from available to prior parties. The instrument must comply with Section 1 of the Negotiable Instrument Law. So, negotiable instrument is a substitute for money, but it's not a legal tender. Okay? A legal tender is only the money issued by the central bank, because a legal tender means is that you cannot force your creditor to receive negotiable instrument as payment. Only legal tender is the money that you can force as payment to your creditor. As I had said, negotiable instrument, although it was invented or designed as a substitute for money, but it cannot replace money. Okay? It says that the difference between a negotiable instrument and a non-negotiable instrument is that a negotiable instrument can be negotiated, while a non-negotiable instrument can only be assigned. Okay. What is negotiability? Negotiability is that the attribute or property whereby a bill, a note, or a check may pass from one hand to similar to money, as to give the holder in due course the right to hold the instrument and to collect the sum payable himself free from defenses. Secondary contracts are picked and carried along with them as they are negotiated from one person to another in the court of negotiation of a negotiable instruments. A series of judicial ties between the parties arises either by law or by privity. As I had said earlier, the difference between negotiability and assignability in the simplest term is that assignability pertains to contract wherein the assignee, this just subrogated to the rights of the prior party. While on the negotiable instrument, the holder has more than the right of the previous party. Meaning you cannot claim real or personal differences. I'll give you an example. You say, you make a promissory note, and you say, promise to pay 10,000 to Juana, or his order, or her order, on what the date, an installment. That is the promissory note. But before before the negotiable instrument or the promissory note was issued, it was intended as a payment for the supplies that Juana had provided to the maker. But unfortunately, the scenario is that the supplies is lacking in number. So it is not enough for the 10,000. So that's when you assign this promissory note, Juana could make Juana could claim that 10,000 is more than what was delivered to her at that time. So that's what's called real defenses. But in negotiation, in the negotiable instrument, you cannot claim that okay, you cannot claim that. So that's the difference between assignability and negotiability. Okay. As we have discussed earlier, when we were reading about section 1, paragraph A, it said it must be in writing and signed by the maker or the drawer. Who is the maker? Who is the drawer? Who is the bearer? Who is the drawee? So we have to go now to discuss the persons involved in a negotiable instrument. First, maker. The person who makes a promissory note and promises to pay the amount stated therein. So a maker is only in the promissory note. It is the issuer, the obligor, the person who is required to pay the amount. Take note, it is only on the promissory note. Drawer. Who is a drawer? Drawer is the equivalent of a maker, but it is not on the promissory note. It's on the bill of exchange and orders the drawee to pay a sum certain money. Like for example, if you're issuing a check, it is the one who issued the check is the drawer. So take note of that. We go now to payee. Who is the payee? The payee is the obligee. That is the person by the terms of the note of the bill is to receive the payment. So, either if you issue a promissory note or the drawer draws a bill of exchange, there is only one payee. The payee is the one who received the money. Okay. We go now to drawee. Who is a drawee? The drawee is the person to whom the order to pay is addressed in the bill of exchange. This is only particular to the bill of exchange. Take note. If we're talking about promissory note, there's only the maker and the payee. The maker is the one who issue the promissory note. See, I promise to pay. I is the maker, the one who promised to pay. When you say pay to the payee, payee, let's say, be the one who receives the money. So that's only in the promissory note. There are only two persons involved. But when we go to discuss the bill of exchange, there are lots of persons involved. First, the drawer. The drawer is not the honest. The drawer is the person who draws or write the check. Drawer. The obligor. Drawer. The payee is the one who receives the check. But there is another person that is called the drawee. Who is a drawee? The person to whom the order to pay is addressed on the bill of exchange. If we are talking about a check, a drawee is the drawee bank wherein the money of the drawer is deposited. Wherein the drawer had a check issued upon, wherein the drawee is the one ordered to deduct from the deposit he has on the drawee bank. Okay, that's already 3 persons involved. We go now to E, acceptor. Who is an acceptor? An acceptor is a drawee who accepts the order to pay made by the drawer. It is only when a drawee becomes an acceptor that he is primarily liable. Okay, who is an acceptor? Say, think of this as, if you are writing a check, let's say, Maria issued a check in PNB. Maria issued a check in PNB, the drawee bank. Maria has a check issued from PNB with the drawee bank to pay Lindo. Lindo is the payee. What Lindo did when the check was issued by Maria, he deposited the check in Metrobank. Metrobank is the acceptor. Metrobank is the acceptor who pay to Lindo by depositing by when Lindo deposited the check in the bank of Metrobank. So Metrobank is the acceptor. So that's there are already four persons involved or parties involved in a check. This is only particular to a check, or a bill of exchange. There are already 4 persons involved. If we're talking about a check, the acceptor usually inquires about the possibility or if the check has a fund to provide for the payment. So it usually inquire from the drawee bank if there is a fund intended to pay for this enough fund to pay for the payee, or if